Hi, my name's Abby Faterick, and I'm here to talk about my second case brief for school law in the Educational Leadership Program at Fredonia State. So the case I am looking at is the Campaign for Fiscal Equity versus the State of New York. It was decided on November 20th of 2006. Now, this case is really important to me because it's focusing on an issue that is still relevant today. It's looking at the 14th Amendment, especially the last part where it says no state shall deny any person within its jurisdiction the equal protection of the laws. So we're talking about how students can be supported in their education. And we're also looking at the funding and how that plays into the equity of students having a sound basic education. This really connects to today because of the COVID situations we're in and the funding that is not coming from the state and federal governments, and districts are having to scramble to figure out what to do, and that's adding more to the inequities in education. So in this case, this is the third appeal by Campaign for Fiscal Equity, or CFE. In 2003, the last time that this case was appealed, the Court of Appeals found that the New York City public schools were lacking funding and children were not receiving the constitutionally mandated opportunity for a sound basic education. In that trial, the court said that they defined sound basic education as the opportunity for a meaningful high school education, one which prepares children to function productively as civic participants. So that's what they really focused in on, getting a more specific definition of sound basic education for this case. And in 2004, the state estimated a minimum cost of $1.93 billion needed in additional operating funds to ensure that New York City public schools provided a sound basic education as I just defined it. So the way that they were going to do this was use the Standard & Poor's School Evaluation Services, which is referred to as S&P, and they use the model of successful schools that studies the expenditures of school districts with a proven track record of high student performance. So when they do this, they weight different categories for the districts to try to figure out how to best support the district to be a high-performing school. So they look at students with disabilities, they look at economically disadvantaged students, and also students with limited English proficiencies. They weight them in according to what they think is best, okay? But an important part to remember in this case is that it's not a clearly defined yes or no, this is the best way to weight each category. So the state was given until July 30th, 2004 to implement measures, and the Supreme Court needed to check at that time to determine if they were being compliant. Okay, so legislature did not pass a bill until August 10th, 2004, and they also provided $300 million in additional education aid to New York City when they did this, but they did not meet that July 30th, 2004 deadline. And so the Supreme Court used a panel of referees to look into this. The referees ended up rejecting one of the filters from S&P called the cost effectiveness filter, and they determined that it should not be $1.93 billion, but actually $5.63 billion that would be needed for the New York City public schools to provide a sound and basic education to their students. So in the end, the New York City Department of Education should be developing a comprehensive plan to make up for this lack of funds. So the actions sought are that the plaintiffs are dissenting against the decision and using constitutional grounds, and the state defendants cross-appealed using constitutional grounds as well as their defense. So the questions to be answered by the court are really two. Should the Supreme Court have used the judicial referee's report and recommendations? And is the amount used by the state of $1.93 billion enough to ensure a sound basic education for the students in New York City public schools? Here's the answer. The role of the court is not, as the Supreme Court assumed, to determine the best way to calculate the cost of a sound basic education in New York City schools, but to determine whether the state's proposed calculation of that cost is rational. And then to the second question, we declare that the additional operating funds of $1.93 billion adjusted with reference to the latest version of the GCEI and inflation since 2004 would be a correct amount and would be enough to give a sound and basic education. So in referring to question 1 about the Supreme Court and using those referees, the opinion states that devising a state budget is a prerogative of the legislature and executive. The judiciary should not usurp this power, and the state, not the Supreme Court, was ordered to ascertain the cost of a sound basic education in New York City. So they did something that wasn't asked of them or in the realm of their power to do this. In referring to question 2 about the appropriateness of the amount of money, it says the use of the cost-effectiveness filter is rationally defensible. New York City could attain minimal constitutional standards while spending less than the higher spending group of successful districts. They can't say that that's irrational. Okay, they're not. There's not enough proof for them to be able to say that that is a wrong amount. As I mentioned at the beginning of the presentation, this is a significant issue today because of the financial equity that's still being brought to courts, and I think that many more are going to be on their way because of COVID. An example, most recently in 2019, is in Rhode Island of Cook versus Raimondo, and they stated that the state is not providing an education that adequately prepares students to participate as informed citizens in civic life. There's also been cases in Michigan and Mississippi that deal with this topic as well. And historically, it kind of looks at how the court will treat cases of educational financial inequities. And we need to look at the majority for this case supports leaving this to the executive and legislator. However, not all judges have this same opinion. Chief Judge Kay, in her dissent, said, "I must dissent because the majority does not resolve the inadequate funding of the New York City public schools and reaches a result that is well below what the governmental actors themselves had concluded was required." Okay, so from her statement, she said that Standard & Poor itself, S&P, repeatedly made clear that it does not recommend any spending level or the adoption of any particular achievement scenario, and that there is a wide range that should be considered from $2.45 billion to $5.57 billion statewide, which translates to $1.93 billion and $4.69 billion for the New York City schools. So she doesn't agree with the bare minimum being taken as what should be given to students to give them a sound basic education. So thanks for joining me. And if you have any questions, please let me know. Thanks.